At times when you want to buy a property here in Nigeria, it can get confusing when it comes to the parts where they talk about the title of the property or the title of the land. Now, I'll be doing a couple of series about different land documents and if any of these documents can be regarded as a property title or not. Now, in the first series, I'll be talking about if the deed of assignment is a title or is not a title. Now, if you are coming across a video like this for the first time, this is Meet the Property Guy Property channel, and this is where we discuss everything in real estate for those who want to buy, invest, or sell a property here in Nigeria. Either you are a first-time investor, you are a serial investor, or you are even looking at beginning to invest here in Nigeria. This channel is the best for you. We share tips, guides, and advice about what to invest, what to look out for, the different risks attached, different property terms, property documents, which you must understand when you are investing and buying real estate. So our advice that after you have watched this particular educative guide, you also go to our previous videos. There's so many topics I've done about shortlet, about land banking, about real estate trust fund, crowdfunding, just a lot of topics which real estate companies here in Lagos and Nigeria which you are going to learn a lot from. So is the deed of assignment a title or not? Now, first and foremost, what is even a property title? Now, a property title is a legal document that represents a claim and a right on a particular property. This property can definitely be either a land or a building. Now, for any legal document to be regarded as a property title, there must be a right to ownership on that property and there must be a claim. If you have a right to a property and you are not claiming that right, you don't have a title. Now, if you are claiming a right on a property and you don't have any legal documents to back up and to show that you definitely have right to that property, then you don't have a title. Now, there are three different ways which you can get title to a land. Now, the first is via inheritance, which means that that property belong to any of someone that you are family related to, and via the relationship, the blood relationship that you have with that person, that property was transferred to you. It can be your father, it can be your grandfather, it can be your great grandfather, it can be your ancestors. Those are customary rights. So via inheritance, you can have a claim or a right to a property. Now, the second way is via conveyance, which is you paid for that property and then the initial seller transferred all his or her rights on that property to you. Now, the third way you can have a claim to a property is via gifts, which means that the property belongs to someone before and then via a free will, a free gift, the person transferred his or her right to that property to you. Now, so that I won't clog the entire video, I'll be focusing on the part where you paid for a property and then the rights and ownership of that property is transferred to you. Now, currently in Nigeria, either is you bought a property in Lagos, you bought a property in Abuja, you bought a property in anywhere, Ibadan, Osun, and Edo, anywhere. Once you have paid for that property, the current land regulation here in Nigeria is a deed of assignment must be signed by both parties. Now, what does this deed of assignment means? Now, the deed of assignment is simply or basically a sales agreement. The seller wants to sell a property at 5 million. A buyer came, negotiated, okay, I can pay 3 million. The seller agreed. Then the buyer paid the 3 million. So the seller, via the deed of assignment, is now telling us that, is now declaring that this so-so property located at so-so address, I've relinquished all my rights and claim on that property to so-so person, which is the new buyer, upon receipt of so-so amount. So in a deed of assignment, there are two parties, the seller, the buyer. And in the deed, the full address of the specified property must be there, as well as the price that the buyer paid to the seller on that property. So which means that if a seller have not received funds, you have not paid for that property, a deed of assignment is not valid. The deed is only valid after you have paid for that property. Now let's go back to the definition of a title. A property title shows that you have a right of ownership. You have the right to own that property, and then you have a claim on that property. Now, since you paid for a property and the initial owner of that property have relinquished all his rights, all his or her right on that property to you, it means that the deed of assignment have transferred all the previous claim of the previous owner, which can be an individual, it can be a family, it can be a company. All their rights and claim on that property have now been transferred to you, which means that with a deed, with a valid deed that is executed means that the seller have signed, the buyer have signed. It is a proof, a valid evidence that you have right to that property, because the deed showed that you have paid. The deed showed that the seller have received the payment that you made, and the deed also showed the full address of that property with a obviously with a survey plan number, and as well the deed also show a covenant, an oath, where the previous seller is transferring his or her rights on that property, including the right of his or her heirs and representative on that property to you, which means that the moment the seller signed that deed, he or she no longer have right to that property again. His or her heirs, either his son, his daughters, his grandchildren, they no longer have right to that property again. And if it's a company, no representative of that company have any rights on that particular property again. So in summary, a deed is a valid title as long as it is executed. Executed means that as long as both parties have signed that deed. Either it is registered or not, either it is perfected or not, it is a valid title, because it shows your rights to that property, it shows your claim to that property, and it shows that the previous owner have relinquished all his or her rights on that property to you. Now, there are some instances or situations that can invalidate a deed. Now, the simplest circumstance where a deed can become invalid is if it is not executed, which means that if it is not properly signed. Now, if it's an individual that is selling the property, then that individual must sign. If it's a company that is selling the property, their directors and secretary must sign. If it's a family that is selling the property, all the proprietary owners of that property, or all the proprietary owners of that property must sign, which means that all the people, for example, a father have a property and then the property was transferred to their 4 sons. Now, if the family are selling that property, all the 4 sons must sign. If 3 of them sign and 1 of them does not sign, the deed is not valid, because it's co-owned. It's not one person that owns it. Everybody in that family, either is a male, is a female, is the firstborn, is the lastborn, they must all sign. So that's the first instance where a deed can become invalid if it's not properly executed. Now, the second instance where a deed can become invalid is if the person that is even signing the deed is not the rightful owner of that property in the first instance. Now, which is something that occurs almost a lot of times. If fraudulently someone sells a land that belongs to another family and the person signs a deed with you, the deed is invalid, because in law you can't transfer what you don't have. So as long as the property does not even belong to that person in the first instance, then that person cannot transfer his or her right to that property to you. So that's another instance where the deed can also become invalid. Now, there are also other instances that can invalidate the deed, like maybe the person has sold the property to someone else before, signed a deed with that person, and then sold to you also. The deed is invalid. Now, the address of the property too, if errors in the address of the property, if there are errors in the names, either your own name, which is the buyer, or the seller's name, if there are errors in those names too, it can also invalidate the deed. Now, going back to title. Now, a title can be transferred to you in two ways, or in two categories. Let me say two ways, in two categories. Now, a title can be transferred to you as the proprietary owner of that property, and a title can be transferred to you as the possessory owner of that property. So they can transfer possessory right to you, and they can transfer proprietary right to you. Now, let me explain what these two means. Now, possessory right means that the previous owner of that property have transferred his rights on that property to you, for you to only possess that property, which means that for you to use that property. But the person is not transferring his claim on that property to you. Just like tenancy. If you put a tenant in a house, you are only granting the person possessory rights to use the apartment or to use the house based on the agreement, but you are not transferring your rights to that house to that person. And that is the same thing with CFO too. When the government are issuing CFO, they are only transferring possessory rights to that individual or to that company. The land still belongs to the government. The only thing that are granting you is that are granting you the right to use that land based on the conditions in the CFO, whether it's agriculture, it's commercial, or it's residential. So they are transferring possessory rights. Now, for most possessory titles, it is for a limited time. It always have a duration. That's why we have a lease. That's why we have rent, annual rent. So the annual rent can be, at the end of the year, the possessory rights is terminated. You have to renew. For lease can be 10 years, can be 20 years, can be 40 years, can be 50 years. In the CFO, it can be 99 years. They are only giving you the right to use that property for that period of time. Just like for CFO, that rights, that possessory rights, you can also transfer it to someone else. Now, a property can also be transferred to you via the proprietary right on that property. The proprietary right means that the person is granting you the right to use that property, the right to own that property, and also the right to dispose that property. So the person that is selling that property to you has no rights on that property again, as long as he is transferring a proprietary right to you. So you can see the difference now. A deed of assignment transfers proprietary rights from one owner to the other person. So which means that when a seller is signing a deed of assignment, he or she no longer have any right or any claim to that property. But if it's a lease, a deed of lease or sublease, then they are only transferring possessory right of that property to you, which means that they are only granting you an access to use that property for a particular duration, just like the CFO too. So these are also some of the things that you must understand about titles: possessory rights, proprietary rights. Now, based on my explanation, again, a deed is a valid title as long as it is properly executed, which means that the seller signed, the buyer sign. Now, if you want to buy any property, as long as you're not buying from the original owners of that property, the original settlers on that property, like the original indigenes, the families of that property, anybody that you are buying the property from, either as an individual or a company, they must present a deed, except they have a CFO. If they don't have a CFO, they must present a deed. Execution gazettes are only root titles, because these are titles the government gave the community or the family. These titles are not in the company's name or the individual name. So a deed actually represents a title in a company name. A deed can also represent the title in an individual name, showing that they paid for this property from so person or so family, and so family transferred all the rights and claim on that property to them, so that the new owners and also they also want to sell and transfer those same rights to you. So that's basically the importance of the deed of assignment. So we have other deeds also. We have deed of sublease, we have deed of gifts, we have deed of conveyance. Deed of conveyance was the previous document that was used to transfer ownership of land before the land use decree. I'm not a lawyer, but I doubt if any current land transaction should be using a conveyance deed. Any land transaction right now should be using a deed of assignment. So we have deed of conveyance. Some very old land have that deed of conveyance. Then I mentioned deed of gifts, deed of sublease, deed of partition. Yeah, deed of partition. I almost forgot that. We have also deed of partition, but I'm not going into all those other ones in this particular episode. So, but for a deed of assignment, and that's why I always advise, when you pay for a property from a real estate company or from any individual, try as much as possible to ensure that a deed is signed. Now, I'll be doing a secure video talking about if a survey plan is also a valid land title. But I'm not going to go too much on survey, but you must always remember this. If they are preparing a deed for you, a deed will tell us the name of the previous owners of that property, which is the seller, tell us the full address of the property in question, tell us the size of the property, 500 square meter, 1000 square meter, 2000 square meter, so and so on. But a deed will not tell us about the coordinates. A deed will not tell us about the shape of the land where the property is situated. A deed will not give us the length and breadth description of that property, which is what the survey will do. So there is a particular section in the deed where they must indicate that a survey plan has been done on that property with survey plan number so must be integrated in the deed. So once someone is going through the deed and they look at the survey plan number, they can easily look at the survey, confirm the survey plan number, and know that the entire description on that survey is what is mentioned in the deed. But I'll be doing a secure video, as I mentioned, where I'll be talking about if the survey plan is also a valid land document. So basically, you have to do your deed and survey together. It must go together. The survey plan number must be indicated in the deed. Because without the adequate information about the exact property that was transferred to you, it can become very difficult for you to lay claim to any land. For example, in a particular street, there are like 10 plots there. Then it's the same owner that owns the entire 10 plots. Then you bought 2 plots out of that 10 plots. Which of the exact 2 plots was transferred to you? So a survey will be done on the exact 2 plots that was transferred to you, and the survey plan number will now be indicated in the deed. So in case you want to take possession of that property, or there is a dispute on that property, you can present your deed, which has a survey plan number, and the survey plan number can back up your claim to the exact plot that you are claiming the rights your right to on that particular street. So that's how it works actually. Now, as I always mention, I am not a lawyer. Don't come to me with some legal terms or something. I can't help. That's just it. A lot of people that know me knows that I don't do things that are outside my scope. So if you want to prepare a deed, you need an attorney. If you want to proofread or review a deed, you need an attorney. If there's any property that you have bought 5-10 years ago and you don't have a deed of assignment signed between you and the owners of that property, you need a lawyer. So there are people I can recommend, yes, but it's not something I will do, and I can't tell you their charge because it's not my job. So that's it. All right. Again, as I've been trying to do now, because a lot of people are not clear about my role and our services. I sell properties. I sell land analysis. So most of the advices, most of the guides that we share here is for you to know what to go for, what to look out for when we are discussing about your investment, when you want to invest, when we are showing you our portfolio and we're telling you that this is for land banking, this is for short stays, this is for buy and flip, this is for rentals, and so on and so forth. So because of the guides and the advices that I've shared here, you'll be able to understand better most of these things that I'll be saying when you want to invest. So we sell properties. I have land and houses here in Lagos, Ogun State, even Abuja. We have some fantastic locations also in Abuja. If you want to invest in any of this location, you can always contact me. Now, I hope I've been able to educate you and enlighten you about the importance of the deed of assignment, and also to give you valid reasons why a deed of assignment is a valid property title. Now, as if being a property on the planet, to property advisor, property consultant, Rabiu Mustafa, thanks once again for watching our video. Thanks once again for following us. Thanks once again for the feedbacks, for the encouragement. I appreciate a lot of you guys. Don't forget, if you have not subscribed, I still want to hit that 1K before June. I still want to hit that 1K subscribers before June. Kindly subscribe, share this video with as much of your friends, so that they can also subscribe and also enjoy from a lot of our guides. Thanks, and see you next time.